Okay, we're just giving people a chance to get into the program here, and we will get started shortly. Okay, thank you all for joining us this evening. Our presentation tonight is called Physician Contract Issues in Light of COVID-19. Our speaker this evening will be Erica Adler, attorney. And before we get started, I'm going to go over a few housekeeping issues. First of all, I want to let you all know that you are on mute. You will remain on mute for the entire presentation, but we do encourage you to use the Q&A box on your screen to type in any questions that you may have. And Erica will answer those following her presentation. If you have any technical difficulties, feel free to type them into the chat box. Slides and the recording of the presentation will be available on the AOA's website, and so that you will be able to get those. They should be available by late tomorrow afternoon. Also, those of you that are attending and hoping to get CME credit, you will need to go back to the AOA Online Learning platform at the URL on the website there. We will also cover this at the end of the presentation. You will go to there, take the post-evaluation, and then from there you will be able to print out or download your certificate after you take the post-evaluation. We, of course, will be providing that information to the AOA CME department. Now, let me tell you a little bit about Ms. Adler. So, Erica Adler, attorney, concentrates her practice in regulatory and transactional healthcare law. She represents individual providers, physician groups, and other healthcare entities in satisfying their day-to-day legal healthcare needs. Ms. Adler has extensive experience in compliance counseling, structuring, and implementing complex joint ventures to comply with state and federal laws and regulations, including Stark, anti-kickback statute, fee-splitting concerns, the corporate practice of medicine, and other restrictions on healthcare professionals. She devotes a large part of her practice to advising professionals and practices on their contracts and compensation arrangements, and in assisting her clients in the acquisition and sale of healthcare entities. She works with providers in matters relating to HIPAA, fraud and abuse, billing audits, government investigations, licensure matters, and contract disputes, and we are pleased to have her here with us today. And I will now turn it over to her. Erica?
Yes, hi, great, thank you so much, Cindy. I'm so happy to be here. Today we're going to talk about some physician contract issues, and I've been working with many different types of physicians and other types of healthcare practitioners over the past couple of months. And as everybody knows, it's been really tough because of COVID. It's affected everybody's practices, both independent and not. And there's some really urgent questions that have arisen out of this. And I think for physicians, it's really important to understand what your contract says, what it doesn't say, what you can do both as an employee and an employer, or even as an independent contractor. So what I really want to talk to you about today is, what does your contract say? What rights does it give you? What rights does it give an employer? And what are some of the situations that I've seen happening over the past couple of months, and it may have happened to you as well, and what are some of your options in terms of dealing with those situations? So first of all, I wanted to kind of talk about some very basic terminology, because we throw this around and sometimes the meanings aren't even really legally clear to a lawyer or to anybody else. So first of all, let's talk, and I'm going to try and keep this very basic. The idea is really just to have you understand the differences. So we have an employee at will, okay? And basically, an employee at will is somebody who really doesn't have a long-term commitment. Typically, they are somebody who can be terminated immediately. So, for example, in most states, they have employment at will, and if you don't have something that says otherwise, like a contract, that means that you have no promise of employment. You're just an employee at will. For non-physicians who work in a practice, this might be somebody like the receptionist, it might be a technician, etc. The type of positions where you don't really have a contract, you're considered definitely an employee at will, and you may not have any promises or expectations. On the other hand, we have somebody like a contractor. A contractor is different than an employee, and there's a couple of differences. I don't want to get into a lot of detail. I don't know how many people might be listening who are really contractors, but basically an employee might be someone who receives a W-2. They may be full-time or part-time, but generally they're told by their employer more about what to do, where to go, where to show up, etc. A contractor, although not always, because not everybody understands these differences and necessarily follows the law, but a contractor is typically somebody with a less regular schedule. They might not be exclusive. They might make their own schedule. So physicians come in both the employee type and the contractor type. And I think most of the situations that I'm dealing with now in terms of COVID really have more to do with employment contracts. And that's really what we're going to focus on. Contractors often, work when work is available, or they might be paid based on a percentage of collection, et cetera. So their situation might be slightly different. But in case anybody's listening who has a contractor relationship, some of these very same concepts will apply to you as well. Now, some of the other terminology that we're really throwing out there is the word layoff, furlough. Okay, those are two words we're hearing a lot. Layoff means you're just pretty much let go, you're terminated. All right, your relationship has ended. Most people who are laid off will go and apply for unemployment, assuming that they haven't been laid off for some bad reason. Obviously, since we're talking about COVID, we're talking about layoffs due to COVID. Furlough. So furlough is really not a defined term. There's really no legal definition. And yet it's become a very popular term to use right now during this COVID situation. What furlough generally means is that you have been let go, but with the expectation of being reemployed. And at the same time, you're really kind of still employed, because many people who are furloughed continue to receive benefits. On the other hand, they can also apply for and receive unemployment. So it's an odd mixture of concepts, this furlough, and it makes it very confusing as to what does it mean when we look at an employment contract. Can you be furloughed? Can you not be furloughed? And we're going to talk about that. The last thing I want to talk about is, what is a written contract? It may seem very obvious that a written contract is a piece of paper that a contract is written on, but a lot of times people have a little memo between them that they both signed. Is that a contract? Sometimes it can be. A document signed by both parties with their understanding is a contract. But most importantly, a contract has to have a beginning and an end, or a way for the contract to be ended. So you'll see that having a written contract is really important. We're going to talk about that's really the foundation of what we're going to talk about today. So what I've been seeing is a lot of situations where employers are facing hardship. There's no doubt about it. If you are the type of practice where you are not allowed, you have not been, because you might have restarted at this point to do elective type of procedures, you may have pretty much been shut down, right? Even if you're not just elective, patients are afraid to go to offices. They're not going. If you're the type of physician who does services where patients might have held off on obtaining care, then you may still not be very busy. And with many physician practices, telemedicine may or may not be an option. So we've seen a real slowdown in practices for a variety of reasons. There's no doubt about it. If you listen to the news, you know a lot of people are being affected by this, getting furloughed, and healthcare workers are being terminated. So we can all recognize that this is definitely going on. But what are employers doing about it? And many employers are doing something slightly different from other employers. And we're going to talk about some of those different things. But what I wanted to point out first is, what are the kind of things that are being impacted by this COVID slowdown? For my physicians that I've spoken with, I've seen that the employer is either demanding or requesting changes in schedule. The employer might be moving the employee from one location to another. I've had doctors who've been asked, who are typically outpatient, to suddenly go into a hospital, to go to cover a different office, that one they've never been to. I've seen changes in compensation. Some have been a percentage cut, a base salary cut, usually somewhere up to 50% modification in compensation. I've seen changes in bonus targets and maybe even a deletion of a bonus entirely. And lastly, a big issue is exclusivity. So employers are often recognizing, hey, you know, I only need you half the time right now, and I'm only going to pay you for half of it. And I appreciate that may not be fair. So maybe you could go work somewhere else, you know, while this is going on. And so those are the kind of issues generally that most physicians seem to be having when we talk about changes to the contract, specifically in light of COVID. So can the contract simply just be modified? That's a really important issue to think about. Most contracts have a provision, and I'm sure if all of you pull your contracts out and take a look, it'll have something in there that says, hey, this contract is everything. You can't rely on any oral agreement. And if we want to change our contract, it has to be in writing, signed by both of us. That is often called an entire agreement provision or an integration provision. And every contract I've ever seen has something like that in it. So that's a really important thing to think about. If your employer is coming to you and saying, hey, do you mind taking a little bit of a pay cut? And you say, sure, I don't mind. Well, that's not good for either one of you, because the employer is putting themselves into a position where you said yes verbally, but you guys didn't sign anything. So now the employee can really go against the employer for not paying what was owed under the contract or breaching the contract. On the other hand, if you've negotiated something else other than a pay cut that's to your benefit, if you don't get it in writing, then you can't enforce it either. Oral agreements are not going to modify a written document that can only be modified in writing. And I think that's really important for everyone to remember. Now, one thing I did want to point out is that sometimes, and this doesn't happen too often, but you may see a provision, and usually it has to do with compensation, that says that the employer does have a unilateral right to modify compensation from time to time. So if your contract does have that and it does occur, then in fact your employer may have a right to do that from time to time. It's very rare to have a unilateral right to modify other things. When I review physician contracts, some of the things I like to focus on from the start are what control the physician has over certain things, including things like, if we go back to this list, your schedule, your location, your call, for example. Those are really important when it comes to a physician controlling their life. So if you did a good job negotiating your contract, hopefully your schedule can't be modified unless the parties mutually agreed. The location you're working at can't be modified unless everybody agrees, etc. So if you have controlled those, or if you've been very specific about what your contract says, for example, I had a doctor who worked outpatient and her employer wanted her to go inpatient, but when we negotiated her contract, we were very specific that she was only working at this particular address and anywhere else by mutual agreement only. And she was able to get out of going somewhere that she didn't want to go, which was for a variety of reasons other than not being cooperative. It was just a variety of reasons. On the other hand, I have another physician who worked for a fairly large group, and her language said something, you will work at this address and anywhere else where the employer might want to send you from time to time. And that was a larger organization that refused to change that. So this organization ended up picking up a site where they were servicing COVID patients, and they needed her to go there. And I could not get her out of going there because that was something in her contract where the employer had a right to do that. So the written word in the contract is really important. If somebody wants to change it, then both parties have to agree and put it in writing. So how does all this fit into what's going on out there right now? First of all, let's talk about termination. Your contract describes your relationship with your employer and the employer's relationship with the physician. It spells out how a contract can be terminated. It usually has some termination for cause reasons, loss of license, loss of DEA, an actual breach of contract. It might talk about death, disability, bankruptcy, fraud, etc. And then it can have some subjective provisions like reputation or conduct, etc. However, never in my life, and I've been doing this for about 25 years now, have I seen a provision in the contract that says you can unilaterally just decide to furlough me, and that would be an okay ground for termination. Or you can just decide to tell me not to come in and not pay me. All right, so the gist of what I'm trying to say is that unless your contract allows you to be furloughed, you're not allowed to do it. Now, the parties can certainly agree that a physician can be furloughed, and that is in fact what's happened in many cases. So a lot of my doctors have been approached and asked to agree to be furloughed, and some of them just said, yeah, sure, and they didn't ask for anything in writing despite my efforts. Many of them, and I should point out that I also represent a lot of physician practices, and we went to our doctors in some cases and spoke, or nurses, spoke to them about being furloughed or spoke to them about amending their contracts. And one of the things that I tell my clients is, look, we've got to do it the right way, because only if you get it in writing will it not come back to hurt you. So for example, if an employer furloughs an employee and that is not permitted under the contract, then what happens is the employee doesn't come in, the employee doesn't get paid, and then that whole period of time where the contract's not being honored is potentially a breach of contract. So an employer who did not get in writing that the employee was willingly agreeing to be furloughed and did not consider that to be a breach of contract has put themselves at risk of being sued for breach of contract. Now, are most employees going to go out there and sue their employers when they agree to be furloughed? Probably not, but many employees were furloughed without discussion, without consent, despite their efforts to talk about it. So there are some angry employees out there, obviously, and there are many breach of contract disputes going on as we speak. So if we also look at what those termination for cause provisions are, compare them to the termination without cause. So most of your contracts will have a provision in there that says either party can terminate without cause on X days notice, and somewhere between 30 and 120 would be the most common provision. So where my employers that I work with wanted to terminate a doctor, or maybe even they wanted to renegotiate with the doctor, one of the first things we did was give notice of termination without cause. That gave us time, somewhere usually closer to 90 days notice, to work something out with the doctor that we could both agree to. And if we could not agree, then the doctor would be finished, his employment would terminate at the end of the notice period. But the entire notice period, that doctor continued to receive full compensation and benefits. So the story here is that if an employer wants to terminate a doctor, they need to look at the contract and say, does anything here match up? Is there any for cause reason to get rid of a doctor? No. Well, then my only choice is without cause. And what the employer should be doing is honoring a without cause provision. Yes, it's going to cost money, 30 days, 60 days, 90 days of compensation and benefits, but that's honoring the contract. Anything other than honoring a contract is a grounds for breach of contract. So that's generally what can and cannot be done when it comes to terminating a contract. So there's some other nuances that are going on here. It's not so easy to just terminate people. One other thing before I talk about amendments and really what's really going on with most physician contracts, I want to point out this force majeure and what we call termination for impracticability. You may have heard these terms being thrown around. And what these terms mean is that a contract can be terminated if something really major happens. And usually force majeure is spelled out to be an act of God, an act of nature, things, it could be things like a flood or a tornado, something that prevents a party from fulfilling their obligation under an agreement. Very smart people might have put in a pandemic, okay? In a physician contract, you rarely, and I can't remember ever, seeing a provision that allowed a physician contract to be terminated for force majeure. It's just not common. It's more common in commercial contracts and other types of maybe real estate contracts, but not in physician contracts, although I can certainly tell you about how we're going to be changing contracts going forward, and we can talk about that a little bit later. If you don't have a force majeure provision in your contract, a lot of people rely on more of what we call a common law approach to a force majeure provision, which is termination for impracticability. The idea is that it's become impractical or impossible for a party to a contract to fulfill their obligations. And in fact, I had quite a few physicians whose employers threatened to terminate them for that. And we fought hard. There's nothing impossible right now. Maybe in the future, if we have a couple more waves of COVID, it may in fact become impossible. But for the particular employers I'm talking about, they had resources to borrow money. There was PPP money available out there. For those of you who aren't familiar, that's the loans that the government has made available. Nothing is impossible right now. So for somebody to claim that it's impossible for them to honor their obligations is simply not accurate right now. And the general sense out there is that no judge would agree that it's impossible for somebody to meet their obligations, at least at this point in time. Okay. One other thing I want to also point out, and for those of you who remember your contracts and worked with a lawyer, whether you're terminated for cause or without cause can also have a pretty big impact on other provisions in your contract. What I like to do is to try and tie in a non-compete provision, the cost of the tail coverage, whether a bonus needs to be repaid, things like that, to the reason for termination. So for example, if you're let go without cause by your employer, well, I want that non-compete waived, and I want the employer to pay for your tail, and I don't want you to have to repay any bonus money. On the other hand, if you do something bad and you're terminated for cause, then yeah, maybe there'll be a non-compete. You pay your own tail, you repay that bonus. So you can see how the reason for termination can impact those things. Well, employers realize this as well, and it's been unfortunate, but in many situations where they should have done the right thing and honored the contract, given the full notice of termination without cause to an employee, I have had quite a few physicians who've had somewhat trumped up for cause provisions. You know, suddenly they behaved badly at a meeting we had last month, or they did something that really is not a valid for cause provision, but was very conveniently used to not only immediately terminate a physician, but to then be able to try and enforce a non-compete provision, make the physician pay for tail coverage, make a physician repay the bonus, and then obviously whether you're going to get paid a bonus or not can often be tied as well to the reason that you're terminated. So when we think about whether something is with cause or without cause, it's more than just those provisions. You have to think about how those fit in with the other parts of the contract. And there's some very savvy employers that have made what I think are some bad decisions. They may save money in some ways because they're not paying the without cause notice period. And you know what? They're making these doctors who they just terminated pay them back money or pay for a tail. I mean, these are really bad acts. But on the other hand, they're probably going to get sued, and that may cost them a lot more. I want to talk about, you know, what doctors should do when these things happen. I kind of, you know, loosely throwing around the concept of enforcing a breach of contract, but you never go into these things lightly. We like to work with employers and doctors to try and work these things out. That is always the first thing you should try and do. And with a lot of my doctors who are approached to, you know, cover a new location or to take a pay cut, etc., initially they're all very angry and upset by it, you know, especially if it's, you know, not been done properly or it's a tremendous amount. But we try and work things out because you don't want to, you know, win this battle and then lose the war, right? As the saying goes, you have to think about what is your relationship with this employer. If you want to keep working with them long term, you were happy, you want things to go back to normal, then we need to find a way to work together. So when this is all over, you can go back. You know, maybe there was a bump in the road, you lost some money, it's going to take a little while to get where you want it to be, where you should be. But it's going to be like that for everyone. And if you want to have a relationship with your employer, then sometimes you also have to think about how you're responding to what's going on. So let's talk about negotiating an amendment. This is really important. Most physicians are, in my experience at least, not being terminated, right? They're being approached with an amendment if the employer is doing it properly. I want to also mention a couple of things. Some employers, are not talking to their lawyers, or their lawyers don't know about the need to have something in writing that amends the contract. And what they're doing is sending out, and I've had this happen so many times, I'm kind of shocked by it because I really think lawyers should know better, sending out an amendment. Please be aware that as of this date, your compensation is being reduced by 20%, and so is everybody else's, or something to that effect. Well, that memo is not enough, and employers really should know better. Sometimes accompanying those memos are, if you don't sign this, your employment will be considered terminated, or a threat like that. If you don't agree to do this, you're going to be terminated. Let me remind you, your contract spells out the reasons that you can be terminated. Anything other than that is not a valid ground for termination and is a wrongful termination. Okay, so for those of you who are wondering, my employer threatened this, my employer threatened that, your employer cannot do these things to you unless it's in the contract. And obviously there's some more nuances to that, but that's the general sense of how you should be thinking about these things. So let's say you're approached with an actual proper amendment. Now, part of the problem is that a lot of my physicians are receiving amendments that just say, you agree as of, April 1st that your compensation is being reduced by 50%. Okay? And I think that that's not enough, right? Sometimes the employer tries to throw in some additional, oh, by the way, we also want you to do this, we also want you to do that. Sometimes they have nothing to do with COVID at all. So some of the things I like to think about, and you'll see on this screen here, is a list of some stuff. First of all, we always want to make sure that it's a document that's going to end up being signed by both parties. We want to get some benefits in there for the doctor. There's some things in there that benefit the employer, but nothing's going to be binding if we don't get it signed. Okay, so no memos or emails should be signed. Secondly, let's keep it on the changes that are needed. Now is not the time to start negotiating irrelevant things just to get an advantage. Okay, so we want to limit it to the changes that are needed. We also want to put in an end date to those changes. So I love the ones that are like, no, you'll take a 50% pay cut until we decide that things are better. Well, what does that mean? What does returning to normal mean? What I like to do is either to set an end date and then say, well, the parties can negotiate again at that time. If I'm representing, obviously, the doctor. If I'm representing the employer, then yeah, I really want you to sign something that's going to go on forever. Okay, but to be fair, somewhere in the middle, we should have some measurement. Is it when the schedule is full again? Is it 60 days after the schedule is full again? Can we use some kind of objective measurement? Can we use a particular date? Can we use a date by which it can not continue any longer, maybe the end of the year? So we need to really think about how to put an end date on that. Another really important question is, will this financial loss be made up? So you're taking 50% of my compensation, you're going to bring me back to normal, but what happened to all that money, right? Some employers got money. Are they going to be making up this loss at some point? And maybe it doesn't have to be immediately, but maybe over some period of time, we can work out some kind of payment schedule. Maybe if you haven't paid it back to me by the time I leave, I get it after I leave, So we have to think about these kind of things. Also, many physicians are concerned about being terminated while they have a reduced compensation. So if you agree in writing to a 50% reduction in your compensation, and then suddenly you're given your notice of termination without cause, you've got 90 days at half pay. What I like to do is say, hey, by the way, I'll agree to this, but if you try and terminate me after you've reduced my compensation, I get my regular compensation for that notice period. This is a little trick that employers are doing, reducing your compensation, then giving you notice so they only have to pay the lower amount. And don't fall for that. That's really important. Okay, sometimes we also want to add in some kind of commitment that they're not going to terminate you for some period of time because you've been agreeable and you've worked with them. I like to suggest maybe a year. Another provision that I like to add in there is maybe a commitment not to further amend. So some of my doctors are concerned that the employer is asking for a 20% reduction now, but then they're going to come back and ask for another 20%. So we want a commitment. Hey, let's talk about everything now, and this is it. Okay, it doesn't mean you can't agree to something else, but we want to kind of nip it in the bud. All right. And then also, some of my doctors might be in a position where they're in a forgiveness period for some kind of benefit, maybe a relocation amount or a bonus or something, and like signing bonus. And so we might say, hey, you know what? I want you to consider that forgiven at this point. I'm being agreeable. This is what I want in return. So these are some things to think about, when you're agreeing to an amendment. So a couple of other issues here. I want to make sure that I leave some time, of course, for us to talk about some questions. But some other concerns are the doctors often ask me are things like, if I do agree to be furloughed, what does that look like? And so what I typically do is an amendment saying, I agree to be furloughed. I agree that any compensation not paid while I'm furloughed is not, I won't make a wage claim against the employer for that amount. I've agreed not to be paid. On the other hand, typically you do agree to continue receiving your benefits during that period. So we like to have that written in. And in fact, as I mentioned a couple of times now, you are entitled to receive benefits while furloughed, even if you're collecting unemployment. So that's an important point to be aware of. Exclusivity is really key as well. And I know I mentioned it early on, but one of the things to think about for many of my doctors may have had their hours cut, may have agreed to compensation, but a lot of doctors have, families to support, they have debt, they have mortgages, whatever it is that you still have your obligations. Just because COVID is going on doesn't mean you don't have those obligations anymore. So some of the things that we like to perhaps negotiate and think about are, can we, negotiate exclusivity? I know I'm working for you, but if I could pick up some hours somewhere else at a clinic or at the hospital or whatever, can I do this? And how do these non-compete provisions apply either while furloughed or if you've agreed to some kind of amendment that you're not working full-time, you're not getting paid your full amount? And these are all negotiable, okay? What I will say is that you cannot just assume that because you've accepted a pay cut or because you're not being used full-time or because you've been furloughed, whether you've done it properly in writing or not, cannot assume that your non-compete provisions are not enforceable. That would be a big mistake, all right? You never assume anything without talking to your employer and trying to get something in writing. So some of the things that we've managed to negotiate are carve-outs from the non-compete, carve-outs from the exclusivity, but we've done it in writing every single time. One thing I might mention is that for employers that have acted badly, they've done a pay cut without putting it in writing, they furloughed you. I've had doctors who are furloughed and then told they're not being hired back. So in addition to not getting proper notice and termination, they lost months of pay where they were acting in good faith by agreeing to be furloughed, even though they didn't get it in writing. So we've got a situation where the employer has breached the contract in quite a few different ways, and there's a really good argument, and this depends on the state you're in and the facts of the situation, but where an employer has done something bad, they're considered to have unclean hands. And where an employer has unclean hands, you can often work around enforcement of a non-compete. So I would be much more likely to tell a physician whose employer has really acted in bad faith, has breached the contract, that most likely the employer would not be able to enforce the non-compete. Okay, so that's maybe one positive outcome of a bad acting employer. Again, I want to remind you that every state has different rules about non-competes and is very fact specific. So please don't make assumptions without talking to a lawyer. One of the biggest misconceptions about non-competes among the physician community is that they're generally not enforceable. And I get told this all the time when I talk to doctors, and that is simply not true. Non-competes are very enforceable. It may be tied to whether the length is reasonable, whether the geography is reasonable, whether the scope of the non-compete is reasonable. But if it's written by an employer who knows, employer lawyer who knows anything, hopefully they've written it properly. And in fact, they can be very enforceable. So please don't assume otherwise. All right, so one of the last things I want to talk about on this slide is productivity. Not every physician gets paid a salary, right? Some doctors are paid based on productivity. That might be a percentage of collections, that might be RVUs, et cetera. So the situation we have right now is if you're not producing, you're not getting anything, right? There's no money coming in, there's no RVUs that are being generated. For these physicians, if they're paid, and really for the small independent doctors who get paid based on a percentage of collection. They're just not collecting anything, so they really have no revenue coming in. For physicians who are paid a draw that is then reconciled against their collections or against their RVUs, they may find themselves in a bad situation at the end of the year, depending on how things go. So just to explain for those who may not be familiar, a lot of times a doctor might be paid based on their RVUs or collections, but in order to give them a steady paycheck, they may get a draw. So for example, let's say they're drawing $200,000 as kind of a salary, but then every quarter or at the end of the year, the employer looks at what their actual production was and says, hey, guess what? You produced more than I paid you, so here it is as a bonus. On the other hand, if the employer paid more than the doctor produced, then the doctor is going to be in a deficit situation. And for doctors who continue to take the same draw while not producing, we may find a lot of them are facing a deficit at the end of the year. Depending on how their contracts read, it may roll over to the next year. It may have to be paid within 30 days or something like that. So really important for physicians who are getting paid based on productivity to understand what their contract says and perhaps consider lowering voluntarily their draw right now if they haven't already, and talk to their employer about how that deficit might be handled at the end of the year. I know we're only in May, but for some practices, they've lost, maybe 2-3 months already of revenue, which can really hurt a physician. One more thing I'll mention is that if a physician is on a guarantee right now, so a lot of young physicians coming out of training might have taken a 2-year guarantee, et cetera. One positive is that I haven't really seen employers modifying the guaranteed basis for those physicians. I can only think of one instance, and I've looked at many of these over the past couple months. So what I have seen, though, is for physicians who are getting ready to start a new contract coming up, I've seen delayed start dates. I've seen amendments of contracts that were just signed already to reduce starting compensation. So just something to think about if you fall into one of those categories. All right, so Cindy, let me turn it back over to you so you can do your part of this, and then we can take some questions.
All right, thank you very much, Erica. So those of you that are listening in, please type in your questions to the Q&A section, and we will answer them following a little bit of housekeeping again on AOA Resources at this time. So one of the first things I want to comment about is the physician support line. This is something that we want to make sure all physicians are aware of, or all providers are aware of, that there is help available out there for you. This could be very overwhelming, and we realize that, and we wanted to share this information with you. Please understand you are not alone, and there's nothing to be ashamed of. Feel free to call them, see if they can help you get through this difficult time. And then moving forward, we have our osteopathic.org/COVID-19 webpage. Please feel free to check that out regularly. What we do is we try to update that with everything that we're seeing across the industry. We want to make the AOA the place that you could go to get all the information you need. So we're trying to compile everything in one place for you so you don't have to search everywhere. So that is being updated regularly. And then moving on, our on-demand webinars, just as this webinar tonight is recorded and will be available for on-demand, these are some of the other COVID-19 webinars that we have done. They are all available on the AOA Online Learning platform for CME. For AOA members, they are free. We will continue to make our COVID-19 webinars free to you as a service, as a help to help you survive this time. And moving forward, some of our online webinars or live ones coming up are the updated telemedicine coding and billing. Last night, Jill Young talked about the updated telemedicine coding and billing and did it more for the physician. The one next week, she's going to gear more towards the biller and coder. Now, we do understand in some practices that can be the physician, so we do encourage you, if that is you, please sign up for it so that you can learn everything you need to based on the changes that have occurred since we originally started this, what are we, 8 weeks out or something. And if it's not you, please make sure to have your biller or coders join. We want to make sure that you are billing and coding accurately for the services that you are providing. And then we have another webinar coming up June 3rd, COVID-19 related concerns, ask an attorney. It will be in a panel of attorneys that will address some questions that come in ahead of time. Then June 10th, we have updating your partnership shareholders and buy-sell agreements. And then we are continuing to work on our reopening your medical practice. We will have a webinar as well as resources to help you on that. And those, if the registration is not open yet, it will be all available on the AOA Online Learning platform at this URL. And then moving forward, again, a reminder that those of you that are watching to obtain your CME, what you need to do is go back to the AOA Online Learning.osteopathic.org platform, put in your username and password. Those should be the same as your AOA logins, and then you will be able to locate the post-evaluation within the course. Once you take that post-evaluation, you can print it out or download it, and know that we will report it to the AOA CME committee. And the next is that should you have any questions about this or anything else related, this is the direct phone line into the Physician Services Department as well as the email. Feel free to reach out to in either way, whichever works best for you, and we will get back to you as soon as possible on that. If there's a question that you have and you're not sure if it should come to the Physician Services Department, don't hesitate to send it. If it is not related to our area, we will track down somebody in the AOA that will be able to respond to you. And then if this is Erica's information, and should you have any questions following, I'm sure you can reach out to Erica as well. And we will now move ahead to our Q&A. So we've had a few come in, Erica. First one.
Okay, yeah, I can see them.
Okay. So
you want me to just run through?
You want to read them or I can read them? It's up to you.
I'll read them because I'll kind of summarize them a little bit.
Okay,
but,
very
so,
good.
Really great question, and thank you for reminding me because I said I was going to talk about this and I didn't, was what do I expect the future of contracts to look like? You know, I'm already working on the future of contracts. So for my doctors, a couple different things. I am definitely putting in language in the termination provisions, unfortunately, from an employer perspective, that will allow employers to immediately terminate a contract if the employer is experiencing something similar to what is going on right now. A little bit more vague, we might call it something like a pandemic or you know, some kind of act of God, but also referring to extreme financial hardship of the employer in the employer's, you know, reasonable discretion, something like that. Is definitely going in there. And many employers are asking me to amend their contracts to allow them unilateral modifications to compensation and schedule to address hardships or situations like this. So those are the kind of things I would expect to see going forward. I've already seen a couple of new contracts recently coming from other lawyers that have those kind of provisions in there. And obviously when I'm on the doctor side, I want to limit them, and I'll probably fight about them a little bit to make them more fair. So don't assume you have to sign a contract ever as it is. You can always try and see what you're able to do with it. So that's something to think about. All right, so have any physicians been successfully asking and receiving hazard pay for working in COVID units when they're normally in outpatient practices? I have not had any physicians successfully do that. Some of them have asked but have not yet received. So unfortunately, I don't have any good feedback on that. The next question is, my employer sent an email or memo stating that our compensation would remain the same as long as we do other things like virtual visits, going to other sites, etc. Is this something I should get in writing? No, not necessarily. I mean, it sounds like your employer is honoring your contract. They're not trying to amend your compensation. If you're saying that going to other sites is something that your contract does not allow, then that would maybe be something you want to get in writing if you have a problem with it. If you don't really have an issue and you don't mind, you don't necessarily need to get it in writing. But certainly any changes your employer is imposing on you that was not allowed or required in your contract is something you would want to get in writing. So you'd reach out and say, hey, I know you're asking me to go to this location. My contract says I only have to work here. I'd like to have an amendment saying that I will go to this location until this date or as long as this continues. Something like that would be what I'd recommend. You know, doctors need to keep in mind that some flexibility here. As I mentioned, you don't want to, if you want to keep working where you're working, you've got to at least collaborate and work a little bit. I mean, if instead of being in the office, you're doing telemedicine or they're asking you to help work on the policies, reopening the practices. I'm extensively working on that for my clients right now. And many other doctors, they don't have patients to see. They're helping to put those policies together for the practices. So I think, you know, that's not so bad if you're continuing to get paid or, you know, keeping busy, have work to do, as long as it's reasonable and, you know, within your specialty, you know, relatively speaking, I really think that that's not an unreasonable request. So obviously everything is very fact specific. All right, so some of your questions are a little bit more complicated. So if I don't answer them, I apologize. I'm gonna try and do a little bit, some of more of the general ones that a lot of people can benefit from first here. Somebody asked if the compensation portion of the contract includes a may amend from time to time wording, is an amendment necessary? I would say the answer is no. I mean, if the contract already says we can replace this exhibit B from time to time just by giving you notice or something like that, that's pretty common language, then no, you don't need to do anything in writing. Nothing, I mean, they've already given themselves the right to do that at any time, okay? So if it says from time to time and both parties must sign off on it, then yes, you would need to get that in writing. Some of the larger institutions in the past few years have really given themselves the right to modify compensation whenever they choose from time to time, or have said that physicians are subject to the plan as it is written, the compensation plan as it is written from time to time, as long as all physicians are subject to it. So if you have a contract that reads like that, and they go ahead and change the plan, and everybody's being treated the same under the plan, you're gonna be a little bit out of luck unless the doctors band together and somehow fight it. So the way the contract is written really does give the employer the right to do those kind of things. And that was, you know, maybe not written in anticipation of what's going on right now, but it certainly has helped the employer in the current situation. Okay, here's a question. We furloughed a physician that was not very productive. I think I just lost that question. Cindy, oh, here we go. We furloughed a physician that was not very productive. We were trying to smooth things over by giving him per diem work. Is this a good idea? I guess my first question for you is, do you have a contract? Did you violate your contract when you furloughed that doctor? If you're bringing that doctor back and you're trying to change the compensation arrangement that you had, is that a violation of your contract? So I don't know what's a good idea or a bad idea. I only know that if you have a contract and you haven't followed it, you need to be very careful about your next steps, and you want to make sure that you're, you know, keeping things as friendly as possible till you resolve the situation. If you do not follow your contract, you are going to be at risk of a breach of contract claim. So obviously, you know, you want to make sure that you are keeping everybody happy to avoid that possibility. If a physician refuses to come into the office and wants to continue to do telemedicine only, can the employer terminate you? Well, I guess, you know, it's up to the employer. If the employer needs a physician to do something and their contract requires a physician to do that, then it's really in the discretion of the physician as to whether telemedicine is getting the job done or not. the government has asked, and as I work on these reopen plans and I read what all the different agencies and different specialty societies are saying, to the extent that telemedicine is viable, then allow your employees to continue doing it. But if you have patients who want to come into the office and you need that particular doctor there, then I think you can require that particular doctor to come in. If some doctors only want to work in office and some only want to do telemedicine, then I'd like to see employers show that flexibility and work things out. So I'm not sure I have a perfect answer for you there. If your employer wants you to come in and you refuse to, and you can't complete your job via telemedicine alone, then I do think that would probably be a ground for termination. Again, we always want to look at how that contract is written in the first place. All right, here's a question. I have an independent contractor who bills under a group NPI. When you guys got the stimulus check from Medicare, you thought you were going to get the paycheck according to the formula listed, but the owner of the practice took overhead on that and gave you 45%. Is that okay? Why should you pay overhead? Well, I guess it's hard for me to answer this without knowing what the compensation formula is. Are you getting paid 45% of collections that are coming in? If so, then I'm guessing that's where that formula came from in terms of the employer giving you 45%. I wish I could give you a better answer. I'd probably have to see your contract to be able to do so. Generally, I haven't actually seen many employers turning over or many practices turning over stimulus money to their contractors or their employees. So pretty impressed that that's even happening. We are having a little bit of a dispute with some employers on behalf of our doctors for not even sharing any of the data about the money that's come in. So what I would say is maybe have somebody look at your contract. I don't know what the difference, the money difference is 40, was it a lot of money? How much is 45%? Is this something that you're willing to do to be collaborative with your employer with your, the company you're working for? And, if not, it might be something worth fighting for. Okay, so have I seen any changes being made to contracts or pay for residents and fellows? No, actually, I have not seen any of those. I'd be really shocked to see that happening. I mean, obviously, residents and fellows are grossly underpaid as it is right now, but I have not seen actually any changes to the contracts for those currently in residency or fellowship at all. And frankly, those are guided by some, guidelines. So I would be surprised to see changes being made to those. The next question says, my contract was for me to see patients at 3 sessions per week and the remaining time to obtain education in research, a grant-funded position. But this time, they have me doing 7 sessions of patient care without any increase in pay and have been told to suspend my educational aspects of my role. Was this legal? Well, that's a really great question. And unfortunately, the answer comes down to, what does your contract say? If your contract says specifically that you do 3 sessions a week for X amount of dollars and you're now being told to do 7, then I would argue that you can't be forced to do that because your contract does not state that. I also think that if you're not being allowed the time to do something that your contract does require you to be allowed to do, that also is a breach of contract. So I think there is possibly an issue with your contract, and obviously you would need to have that looked at. Again, try and talk to your employer, look at the specific language, talk about whatever's happening, how it differs from what your contract says. Maybe you can come to some agreement. Maybe it's an increase in pay or a decrease in the number of sessions or better respect for the time that you're supposed to be doing your research. So we really always have to kind of balance all of these issues together if you're interested in continuing to have a relationship with your employer. Here's a question. On a company town hall, there was talk about doctors that are over 60 and chronic illness and may not have those doctors work in the future with pandemic situations. Okay, I'm not entirely sure what that question is. Right now, I haven't seen anything changing in any of the guidelines that are out there, but certainly every employer is required to take into account any particular disabilities or issues that particular employees may have age alone is obviously not a disability, but any employee, regardless of age, that has chronic illness may have issues they need to discuss with their employer, and then an analysis of risk in the workplace should be done. So generally, for physicians, depending on the kind of workplace you're in, if you do have any kind of conditions that are impacted by COVID, then you may, your employer is typically, when you have a disability, required to accommodate you. So, for example, that question we talked about previously, telemedicine. I mean, if you have a chronic condition and you can take over seeing all the telemedicine patients, would that be a reasonable accommodation for an employer? Yes. In fact, I have a client that I work with, and there's a physician with a disability, and they have told that physician to stay home. She is working actually with me on helping to do some of the reopening plans or the revival plans, because this practice has been partially open, and she is now also responsible for all the telemedicine visits. So keep in mind, if you are a physician with a disability, the employer does have to accommodate you. That's a little bit different than a contract issue. That's a disability issue, but these do kind of play together in these uncertain times of COVID. All right, one more question here and then we'll be done. So I have a question, I believe, from a physician who was on disability. It sounds like before COVID happened, but there were no elective surgeries in the state, and so the physician is now unable to work until surgery, which won't happen for quite a while. You have an employee contract until the end of 2022, and the physician has short and long-term disability insurance through the company. So that's the background there. The question is, can I be terminated if I'm unable to go back after surgery and have to go on social disability? Current contract goes until past 65th birthday. Well, there's a lot of different facts going on there. I'd be interested to see how your employer is willing to work with you here because of COVID. Most contracts provide for termination after a certain amount of absence from a practice. So most of your contracts will have provision that says that a physician may be disabled after a period of X number of weeks. If the group is big enough, they're covered by FMLA, but that really just provides the 12 weeks of unpaid leave. So there is a certain point at which even a physician practice is not legally required to keep a physician on. I would want you to look specifically at your disability policies in your practice, what your contract says, and what your rights may be. Unfortunately, I can't say that your employer would not have a right to terminate you. You say you have a contract that goes for quite a while, but one of the things physicians often understand is that a contract is only as long as the notice provision. You could sign a 10-year contract, but if it has a 90-day notice period, it's a 90-day contract. So that's one thing to keep in mind as you go forward is that your contract is only as long as that notice provision. So, or I guess as long as a disability provision in this case. Okay, I hope that was helpful. I probably would need to take a look at your contract and talk with you to give you a better answer to that. All right, we got one more question here. If an employer blatantly breaks the contract, what laws are in place to make certain he or she honors another written amendment? Well, there aren't any laws per se. So if a contract, if an employer breaches a contract or breaches an amendment, the rights that an employee has is to bring a breach of contract claim. But you're absolutely right. If an employer breaches something, you call them on it, they say, oh, we'll fix it. Let's sign this amendment. What's to say they're not going to do it again? Nothing. So what we try and do is maybe work in some penalties. We might work in that the employer is responsible for legal fees if they breach, or maybe they have to pay some kind of damages, or they might owe you extra money. There's lots of ways that we can kind of incentivize an employer to comply with the contract, or at least put them in a position where they will be penalized if they don't. So there's really no laws other than, contract enforcement. But if you're clever, hopefully you can put together an amendment that incentivizes the parties to comply. That's the last question we had. So feel free, please, to email or reach out to me if you have any other questions. I'm always happy to answer any emails that I receive. And thank you so much for having me. I really enjoyed this, and I hope everybody benefited from this discussion.
All right. Well, thank you so much, Erica. It was great. I know you covered these last two questions that we talked about that came in through email, but just because people like to hear their actual question asked, I'm just going to put it out there. Can a contract be termed if the physician doesn't accept a pay reduction or furlough? And if so, is that cause?
So just to be clear, your contract can only be terminated in the ways the contract says it can be terminated. So unless you have a ground for termination that says physician refuses to agree to a change in compensation, then the answer would be no. And an employer who says, if you don't take this change, I'm going to terminate you for cause, would open the employer would be opening themselves up to a breach of contract claim. That would be a wrongful termination.
Okay, and I'm assuming this would be the same for this one. I have a new employed physician 2-year guaranteed contract. Can they break that due to unforeseen circumstances such as COVID?
Well, you're absolutely right. It's the exact same answer, right? Unless COVID was a ground for termination in that contract, you cannot terminate it for COVID. What you can do is give proper notice of termination without cause. You eat those 60 or 90 days worth of pay that you owe that doctor who's on a guarantee, and then your relationship will end. But if you don't follow the contract, you're opening yourself up to a lawsuit, and physicians deserve to have their contracts honored. So you always want to honor that contract as best you can.
All right. Well, thank you so much. Again, wonderful presentation. Great job. I truly do appreciate it. Thank you all for joining us, and this concludes our webinar for this evening.